tons of ads out there for all these lawyers. We can get your money back. Some states have limit laws that applies to purchases. So manufacturer's going to send them a check to fix it. Let's sign on. Let me give you a retainer fee. Well, it only recovers legal costs if they're in breach of warranty. Now, talk a little bit about limit laws and misconceptions out there. People think that everything and anything is a limit. Their car has a limit, and they're going to win the lawsuit. I'm going to give some little bit of facts so you guys can read between the lines versus going out there and spending money on a lawyer, giving them a retainer fee for something that should apply to you. A small number of states additionally have more limit laws that cover used vehicles. So some used vehicles are covered, but it's very small. It's got to be a used vehicle with a manufacturer warranty. That means low miles. And I'll get you specifics on that. New York State is one state with used car limit law. Of course, California has its own. Some states have limit laws that applies to pet purchases. So if you have a dog you bought from a store or a breeder, you have some limit law stuff to protect you, especially you have issues with that dog. California has a broad limit law. It's actually called the Song-Beverly Consumer Warranty Act. So that's one of the laws. It's not called the limit law, although when you Google it, it's going to come up, and probably tons of ads are going to come out from lawyers saying, hey, we can take care of you, which covers a wide range of products, including vehicles, boats, electronics, and appliances. The Song and Beverly Consumers Act, also known as the California Limit Law, is a California statewide that protects consumers who purchase or lease defective consumer goods, especially vehicles. It requires manufacturers to honor, express, and implied warranties and provide remedies when products cannot be repaired after a reasonable number of attempts. The Song and Beverly Consumer Act, also known as the California Limit Law, is a California state law that protects consumers who purchase or lease defective consumers goods, especially vehicles. It requires manufacturers to honor, express, and implied warranties and provide remedies. Cannot be repaired after a reasonable number of attempts. So that's a summary right there. So I want you to listen to the last sentence where it says it requires manufacturers to honor, express, and implied warranty and provide remedies. Most dealerships are going to provide a remedy when a product cannot be repaired after a reasonable number of attempts. Now, it's not saying after 3 attempts, after 4 attempts, after 5 attempts. It's a reasonable number of attempts, and it kind of just leaves it open. That's where you would go into litigations. Okay, I've been in there 10 times, but each 10 times it was 10 different issues. I don't know if you would get a reasonable number of attempts on 10 different issues. On one issue, maybe, but that's saying if they cannot repair it. And it wants the dealership to provide remedies. So another remedy is say, hey, give this car back, go choose another car off the lot. That's a remedy versus saying, hey, I want my money back, I want my car back, I want to buy from a different dealership. That remedy, the corpse might accept it. Let me go on to reading the key aspects of the Song-Beverly Act. Implied and express warranties. The Act mandates that all consumer goods sold in California with a warranty are subject to implied warranties of merchandisable and fitness for particular purpose. It also requires manufacturers to uphold and express warranties they make. Now, a lot of them don't give warranties. So if you buy a car off the lot, you don't want to purchase the extended warranty, they have you sign a paper that says sold as is. I think you're kind of screwed with that. Once you buy the car, you're buying it as is. When it comes to this act, and it says are subject to implied warranties, so no warranties was signed off, that's my implied warranty. So if you have a vehicle, you bought it used, and you were in the shop 10 times right after, well, you have an implied warranty, which is none. Say you do have a warranty. Reasonable number of repair attempts. If the manufacturer cannot repair a defect within a reasonable number of attempts, as defined by the Act, the consumer can choose between replacement or a refund of a purchased price. Once again, you can choose between there, but what's the reasonable number of attempts? Because you've been in there 2 times or 3 times, or it was super expensive, or was out of pocket, it wasn't under warranty. so you got to think about that. What's the reasonable number of attempts for the repair? And only a judge can really determine that. Remedies for breach of warranty. Remedies available to consumers for breach of warranty include damages, equitable relief, civil penalties, and recover of legal costs. Okay, this is saying that the dealership is in breach of the warranty, so that's more like if the dealership does not want to repair or refuses to repair. I bet you they're going to repair it or try to repair it. And in this case, if they refuse to repair it or don't repair it at all or don't touch it, it's not saying they didn't attempt. This is saying they didn't do it. Breach of warranty. You can recover your legal costs. And when you Google online, the Lemon Act, there's tons of ads out there for all these lawyers. Yeah, we can get your money back. If they're found guilty, they're gonna pay for the legal fees and stuff like that. And everybody thinks, oh well, good. Let's sign on. Let me give you a retainer fee. Well, it only recovers legal costs if they're in breach of warranty. Now, there's other areas that the judge might say, hey, we'll cover the warrant. We'll cover the cost. You were negligent here as the dealer and this and that. But these laws are kind of still open. There's not exactly specifics. This act applies to a wide range of consumer products, including vehicles, manufactured homes, other goods sold in retail California. So it's not just cars. Obviously, it's on dogs, animals, cats, rabbits. Let's talk about the used vehicles. This act also extends to used vehicles under certain circumstances, especially those with certified pre-owned warranties or dealer written warranties, still covered by the manufacturer original warranty. Okay, so the manufacturer has its own warranty. So remember, the dealership is almost like a franchise. The manufacturer is the moneymaker, the person who made it. The manufacturer carries, say, 36 months warranty, bumper to bumper. If your car has 20,000 miles on there, you're covered by this law because the manufacturer should fix it. The dealership should fix it because they're going to get paid by the manufacturer. Remember, they're independent. They're not the manufacturer, and so they're going to make money from the manufacturer. Manufacturer's going to send them a check to fix it. So if you got a certified Honda, let's say, it should be covered under there. If it's under 20,000 miles or 36,000, some manufacturers have 80,000 mile warranty. So if it's under that, it's covered under the manufacturer, and it should and it will be covered under them. Sometimes these manufacturers want to see oil changes to the T every single 5,000 miles, every single 7,000 miles, whatever it calls for. And then when you send them all the invoices and then they see the wrong oil on there, you're done. They're not going to cover it. Statute of limitation for filing a claim under the Song-Beverly Act is 4 years from the date of breach of warranty. However, the clock doesn't start ticking until the consumer realizes the manufacturer cannot fix the problem. So you got 4 years. There's another law out here, and it's called, where is it at? I can't say this. Magnuson-Moss Warranty Act. It was enacted as federal law in 1975. This law says if your car gets deemed lemon, California consumers have 18,000 miles or 18 months from the date of purchase to return it. So there's two different laws there. I don't know which the judge will side with, but one is saying 4 years and the other one is saying 1,800 miles. And this is a federal law. Song-Beverly Consumer Warranty Act is a California law versus the other one's a federal law. The provisions for vehicles, if the manufacturer cannot repair the defect after a reasonable number of attempts, they must offer replacement, repurchase of the vehicle, or repurchase of the vehicle. So you got to buy it back. Consumers are not required to accept a replacement if they choose reimbursement. Yeah, there's a lot of misconceptions out there on the California lemon law. Okay, I googled California lemon law right away. There's ads coming out. Is your car 2021-26 lemon law refund calculator? So there's a calculator on that. They're getting you all hyped up. I haven't pushed the calculator, but I'm assuming they're going to give you some type of number. Hey, how much money are you going to get back? Generally, it's not like money coming back. They're just going to refund your money. If you're out of pocket because of a fix, that's kind of rare. Like, why would you be out of pocket if there was a warranty on this? You should have took it back in. Now, if you were out of pocket because you were out of warranty, kind of fixed it, then we're back to the law. Like, implied warranty. Like there was no warranty on this, or they gave you a 90-day warranty and it was written and it's past the 90 days. Limit law refund calculator, I think that's to hype you up and get you to come and sign up and say, hey, now there's a lot of good lawyers out there, but when I see some of these ads coming up, it makes it seem like, yeah, we can get it for you, and we'll work on this and we're really good at this, but your retainer fee's X amount. I'd be worried about the retainer fee versus somebody just to take it for free. If you have a real limit law, they should take it for free. And California limit law update, key changes under AB 1755. In recent years, the number of limit law cases filed in California under Song-Beverly Consumer Act has surged from about 15,000 in 2022 to over 22,000 in 2023. Wow, that's a lot. That says a lot for the manufacturers and how they're making cars nowadays. And more than 25,000 in 2024, placing a strain on the court systems and delaying case resolutions. To address these issues, Assembly Bill 1755, enacted in September 29, 2024, aims to streamline the limit law process. Effective 2 phases beginning January 1st and April 1st, 2025, introduces new procedural guidelines, including the early exchange of discovery document, expedited dispositions, and mandatory mediations with 6 months after the answers is filed for those manufacturers elect to be governed by new procedures more commonly known as the opt-in requirement. So now they want you to go to a third-party mediation, kind of like a divorce. Let's figure this out. Let's mediate this. So that's some new updates right there. They just want the process to go faster versus hitting the courts. They don't want you to see the judge, they want you to see a mediator. California limit law applies to new, used, and leased vehicles. It covers your car if there's a problem that makes it hard to use. Maybe your brakes are out. They're going to fix that, Lowers its value. I really don't see how something would lower the value if they fix it. Or if they can't fix it and you can't resell it and lowers the value, then that's a plus for you. Or it makes it unsafe and the dealer cannot repair the defect after a reasonable number of attempts. We're reading that again. If the dealership can't fix it after a reasonable number of attempts, then you got a case. But you don't got a case if it's after the manufacturer warranty or after their warranty. For used cars, for used vehicles, the state's limit law applies when it's still under the manufacturer's new car warranty. Any remaining time left on the warranty protects the car's new owner. So we're back to it again. If you're 5 years into it, there's no manufacturer warranty. Well, maybe Hyundai. Hyundai has, I think, a 5-year warranty, 100,000 miles warranty. That's because their cars are crap and they were forced to give that warranty. They had so bad engines, manufacturing bad engines that United States forced them to give a lifetime warranty to certain Hyundais, and either that or get out of the United States. So they had to abide by that. California extends the limit law to active duty military personnel transferring to the state after purchasing vehicles in another state. Okay, so here's something interesting I found on the internet. This is suits against car companies under California law from 2018 to 2021. So this is not even recent. This is older. General Motors between 2018 2021, total vehicle registration. So this is how many cars they sold. 771,809. Total limit case filed 9,892. Limit law case filed, that's 29%. Fiat Chrysler Automotive, they sold 618,355. Limit law cases 5,798. So that's 17%. Ford, I'm gonna just go to percentages, is 13%. Nissan North America is 12%. Honda is 5.9. Remember, I've told you guys in the past, by Toyota, Honda, 5.9. They have less cases filed against them. Volkswagen has 3.2. That's a shocker there. Jaguar has 3% of their vehicles limit law case filed. Mercedes-Benz 2.7, BMW 2.4, Hyundai 2.2. That's so hard to believe. Well, 2.2 is because nobody's making cases against them because the high warranty. They have a 100,000 mile warranty. If not, some of them have lifetime warranties. So you're just going to go to a dealership and they're just going to replace it. But Hyundai has tons of problems, tons of issues. Toyota, remember Honda and Toyota, 2.2%. Subaru of America has 1%. Tesla has 0.6%. Tesla has a real good warranty, so I know some people that work there, and I don't know if they have issues with warranty, but they fix everything. I mean, they'll come to your house and fix it. So that's why it's so low. Tesla has 0.6. Porsche has 0.5. Porsche, Mercedes, BMWs, they're luxurious cars. Luxury cars, I'm sorry. Usually people with money have those, and they don't really go to the dealership and ask for discounts or anything. They just go and, hey, fix my car, here's this. Whether it's under warranty or not under warranty, they don't care, you know. So that's why I think there's low numbers when it comes to Volvo and all that stuff. Mazda has 0.3%. Yeah, Mazda's true. I hardly see any of those cars. Maserati 0.1, Mitsubishi 0.1. So all the high numbers for limited loss cases is percentages is General Motors, Chrysler, and Ford and Nissan. That's all domestic vehicles. So domestic vehicles have the biggest issues. We need to keep up with all the foreign vehicles because they have less limit law cases filed against them. So it comes down to disputes can be resolved through. So what it comes down to is if you do end up suing or you hire a lawyer to sue, it's gonna come down to mediation. So mediation, they're gonna try to figure things out. Usually mediation, the mediator gives recommendations, and the court's just gonna side. If it hits the court, no agreements, it's gonna side with the mediator. And the mediator's job is just get this over with. We don't want to waste time with it. So I don't think a lawyer's gonna solve issues. The mediator's gonna solve issues. So this is so guys, so what we learned today is the limit law is basically for written warranties, extended to military if they move from one state to another state. Manufacturer warranties are covered, but if they give you no warranty and it's written, which they'll have a piece of paper. I've signed those at dealership, sold as is. Then that's your warranty right there. No warranty. So this is just information for you to figure it out. Document everything, guys. Every time you go to the dealership, every time you go to a repair shop, if they fixed, example, the transmission, and you feel that transmission is having issues or shifting funny, when you come back to the shop, make sure it's logged in and you get it, even if they don't charge you to test it. You know, you come back in and they're like, let me take a look at it. They grab your keys, send it to the back. Okay, we fixed it. We found the loose wire. Boom. Cool. They're a good shop. They fixed it, but get your paperwork. Because what happens if you come in for warranty and you come in 4 times and you're getting tired of it, well, the other 3 times that you came in, you have no proof that you came in. What are you talking about, Judge? She came in for transmission. We didn't see her for 3 years, you know, and now the transmission she misuses. She didn't do no flushes, no service to it, no filter changes. You know, they can do all kinds of stories. So every time you go into a shop, make sure that you check it in and say, here's my keys. Can I get my invoice for checking it in? And here's my symptoms, you know, and make sure that it's on the invoice that, you know, your symptoms aren't there. One time I went to a dealership and I told him, this is our 4 things that are symptoms that I have. And all he wrote on the invoice was check engine light. I said, no, this is not what I'm here for. I'm here for these 3 symptoms on top of the check engine light. If that guides you there, but these are the symptoms that I want solved. But anyhow, guys, what I'm getting at is that when you go into a shop and you go in for warranty, make sure there's you're checking in the vehicle and you check out with the separate issue that names how they remedied it. They found the loose wire. They plugged in the wire and it fixed the issue, you know. So anyhow, guys, if you guys have any questions or comments on the limit law, feel free to subscribe, hit the little bell button, and let me know if you have any questions. Thanks a lot, guys. This is the Centric Boys, San Marcos.